The final matter to come before the court this morning is Jeremy Thompson versus Rebecca Thompson. Counsel, we just received notice that counsel on the other side is held up in Lorain County and will not be able to make it for oral argument this morning. That means that once again you have 15 minutes to argue the case and make the presentation as you choose. The court's read the briefs and we are ready to see what you want.
Thank you, Your Honor. Attorney Greg Price on behalf of Rebecca Thompson, the mother in this case, Your Honor. In this case, the court is asked to address a DVCPO, and specifically what we're asking the court to address is the testimony and the procedure of approaching the court with the DVCPO. This case started after years and years and years of litigation in the Medina County Domestic Relations Court. And I think it's been at least 6 years before this DVCPO was filed. Mother had had custody throughout the duration of the case. I received a call after this proceeding. So mother represented herself at these proceedings because she thought that the court would surely be able to look at the 6 years previous and be able to say, look, that's not what's going on. Here's what's going on. She didn't fully appreciate the fact that whenever a court gets a new case number, that docket and that court file doesn't immediately follow her. So in reading this transcript, the concerning aspect of this is that once again we're dealing with quite possibly the most severe civil sanction we can hand down to a person. In this case, you're dealing with the most severe sanction you can give to a parent. So Ms. Thompson went from having residential custody of the children with father having visits to having zero contact with the children and losing custody of the children. Now, it is imperative to look at this transcript. It's imperative to look at the facts. I know I say that all the time, but if you are reading this, you'll see that father's entire case was father took the stand and father just testified as to what the children told him, and then his wife took the stand and testified as to what the children told him. Mother...
And the two were not the same. I'm taking extrapolating.
They were a little bit different. I think father...
So what's the point then?
The point is, whenever you're dealing with something of this significance, whenever you're dealing with any trial, if the only evidence presented is the testimony of the person that filed saying, oh, here's what the actual claimants are saying. Father was not filing a DVCPO for himself. He was filing for the 3 children. At no time did any of the children come to the courthouse. At no time did they give any testimony. At no time was it shown that they were incompetent and therefore couldn't testify. Rather, their ages are appropriate, their schooling is appropriate, their grades are appropriate, all that testimony is in the transcript. They just never came forward to testify. And I understand that whenever we're dealing with situations like this, and we're dealing with young children, and we're dealing with hostile environments and families, we don't want children being placed in the middle. There's an absolutely easy resolution to that, which is you ask to have a guardian ad litem appointed. That guardian ad litem can then come in and speak for the children. In this situation, you have father filing a DVCPO for the children, and then him coming to testify for the children. And that's all the evidence that was placed before the court. And really, that's troubling.
Well, there was a photograph, right?
I don't think there was even a photograph. There
Well,
might have,
I thought I read, maybe I'm mistaken.
and I'm not going to say there wasn't. There might have been.
About the teacup and the hole in the wall.
And that's another problem with this case, is that father came to the court with the filing and said that mother hit the child over the head with a vase, which is extremely concerning. But as he actually stood up to testify, he said, no, what the children told me is that mother was cleaning a dish and it flew out of her hand and hit the wall, and part of it hit his daughter. And then, whenever he has the one child being, if you can even stretch the definition of abuse to encompass that action, he then extrapolates that to say, and I've talked to the children, and all the children knowing this are terrified to go home, and that therefore means that they are abused as well because they fear the imminent threat of going back home. There's absolutely no testimony to support these children's belief or their fear or the harm other than father testifying for them.
Well, Mom said that she dropped the teacup, right?
Correct. She dropped the teacup and part of the teacup hit the dog.
Where did the hole come from? That's what the trial court kept saying. Well, where's the hole come from if you just dropped the teacup?
And that's not what the testimony was she was washing dishes, and as she had the teacup, it slipped out of her hand and hit the wall.
And made a hole in the wall.
And dented the wall.
And then the court is saying that's just not credible.
And that's concerning as well, because the court is then saying, well, mother's own testimony about what mother did is not credible. However, Father testifying as to what the children said and their fear and what they would like to see happen is credible. That's another concerning part of this, and that was the second aspect of this.
Does mother say at the hearing that, or admit at the hearing that Jobs and Family Services has been to her house regarding incidents?
Oh, Jobs and Family Services has been to both of their houses throughout the case.
But as it relates to her house and her treatment of the children in that home?
Oh, yes. And once again, that comes from Father, who says CSB has been to her house several times.
But my question was, does mother make that acknowledgement?
I believe she does. But at the same time, she says, look, this case has been going on forever, and they've been to both of our houses. They've been to his house. And if you want to look at credibility and look at CSB reports, which they offer none, they never say when they came, how often they came, when the worker came, and more importantly, they never give you the end result. That for 6 years, they've been both making complaints to CSB, and CSB has, or I guess in Medina County, it's Job and Family Services. Job and Family Services has come to both of their houses. And after all that, nothing has happened. Mother has been the residential parent the entire time. So the court takes, once again, Father's statement, that is, once again, hearsay. It absolutely requires, under Rule 1000, that if you're going to make statements about reports and records, you need to supply the court with those reports and records. They never did any of that. He just said, I have called them several times to complain about her. And then the court finds that extremely credible. And the court finds mother saying, look, they never did anything, incredible. So where the court chooses to make credibility and not credibility is concerning as well. Because you have a father who's completely self-serving, testifying about what the kids want, and then making these revelations about what has been going on in the past. But then when mother steps up and says, no, this is what really happened, she's not credible. But here's the real problem. If this court is to allow this to stand, this is absolutely going to be a bloodshed for DBCPOs. Because this father had spent 6 years trying to get his kids, 6 years trying to get custody of his kids, 6 years arguing with his wife as to why he can't have more time. The Medina Domestic Relations Court has routinely said, you don't get more time, mother is the residential parent. In this one hearing, where he sidesteps the Domestic Relations Court, goes and gets a new case number, the guardian ad litem from the previous domestic relations case is never contacted, the previous domestic relations attorneys are never contacted, he never gives service on the previous domestic relations attorneys. He simply shows up, files this one piece of paper, and he now has custody. Not only does he have custody, mother is never allowed to see the kids. So what he has effectively done is used a DBCPO to get a modification to his parenting time, based on solely his testimony. Nothing more self-serving than that. But more troubling is that he has completely circumvented 6 years of litigation and the guardian ad litem that had already been appointed to the domestic relations court case. He gets away from all those people by simply doing this. And if this court is to uphold this decision, that's going to happen every day, all day. In fact, if the court upholds this decision and somebody comes to my office and says, for 10 years I've been trying to get my kids, and for 10 years I just want more time. The first thing I would say is, you probably need to file a DBCPO. You'll get the kids all you want. All you got to do is tell the court that your kids are terrified of mom. Because that's all that happened in this case. Father came to court and said, I have talked to my kids, they are terrified.
He was represented by counsel, wasn't he?
Yes, he was.
Well, I would hope counsel would not ever recommend that, because I think there would be some problems.
That's an extremely shady situation, and that is the extreme of the situation, but that is absolutely going to happen. And it's going to happen on a routine basis. And you can't even say that it's shady because Mr. Thompson might truly believe that his kids don't want to go home. Might truly have talked to him and they said, you know what, I don't want to go home. I don't like mom's house.
Or they are fearful of her.
Correct. And then all of a sudden they say, look, you don't need to worry about the domestic relations court. We're going to go to DBCPO.
You're asking us to assume that counsel would make those representations.
No.
Light of all of counsel's ethical obligations.
And I am being rather facetious to a point, Your Honor, but I'm not asking you to make a leap. Because what I'm telling you is exactly what happened here. It's not his attorney saying, look, we need to do this. It's Mr. Thompson coming to his attorney and saying, look, I talked to my kids, they don't want to go home. Well, instead of filing an emergency action with the DR court, where they've already known Mr. Thompson for 6 years and told him, no, that's not going to happen, we'll go to a new magistrate with a new case number. We don't even have to give her attorney notice. This is what we're going to do. And once again, the key to this, I think, is he never filed a DVCPO for himself. He filed it for his 3 children. And not one of them testified, not a guardian ad litem appointed. He never requested a guardian ad litem because he knew that if he requested one, they would look for the last guardian ad litem and give him that same guardian ad litem.
Now, as I recall, CSB was called, but I don't remember reading what the police were called.
The police, and in this case, I'll tell you right now, the police have been called several times.
No, I'm actually what's in the record.
Oh, just in the record? I think the police were called, and I don't think anything happened. And once again, the police were called, CSB were called, they interviewed mom, they interviewed dad, all that's in the record. But if CSB had done something, we wouldn't be in DVCPO court. If the police had done something, they would have called JFS, who then would have said, look, we're going to file a motion, we can take the kids out. But none of that happened because they had to file a DVCPO. And none of it happened because it's all happened before. And Mr. Thompson lost every single time. And if the court doesn't have any more questions, that's really the sum and substance of our argument. Would ask that the court remain this back to the trial court or truly just dismiss this for lack of any kind of credible evidence. Thank you.
Thank you for your presentation this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. We are adjourned until Thursday, Senate Council.